Secondly, in section 12B29, it's talking about scaled location area maps that identifies the relative locations of and distances from public parks containing playground equipment, and provide that the measurement for buffering distances from public parks should be based on public parks without a reference to playground equipment. Councilwoman James flagged this at a previous reading of this ordinance. And so if this amendment is so proposed, it strikes in section 12B, subsection 29, it strikes the phrase containing playground equipment and from the playground equipment. So that way the language just removes that playground equipment reference. Is that still your motion, Councilwoman James?
Yes.
Is there a second?
I'll second.
It has been moved by Councilwoman James, seconded by Pro Tem Carrington, that the containing playground equipment and from the playground equipment language be striked in section 12B, subsection 29. Attorney Murphy, any further context you'd like to provide this council?
Well, the prior zoning ordinance for medical created a 500-foot buffer from public parks, and there was some concern with one particular park where some playground equipment disappeared overnight, and there was a concern about not having to change the buffering measurements based on where playground equipment was located. In addition, apparently parks are going to be renovated and playground equipment is going to be moved, so the thinking was that it was a more feasible measurement to measure to the entrance way to the park from the controlled use, which would be a marijuana facility.
And so to clarify, this does not have any ramifications or bearing on setback distance, or would it? It's not changing necessarily the definition, it's just changing the scaled map, what they're required to submit with the application, sort of what the scaled map would and would not have to reference. So it's bringing back on the requirement, they would have to have maps on their, parks on their maps. It's not just parks with playgrounds.
Well, it would be a public park, and this really dictates how you measure the buffering distance from the controlled use to the park. Instead of it being to the playground equipment on the park, would be to the entrance to the park, or the closest location where the park begins from the measuring technique that's used in the zoning ordinance.
Councilwoman James.
Yeah, are we still going to use the 500 feet because that's not in there, or is that still going to be the standard that we're looking at?
The 500 feet is going to be in the zoning ordinance.
Okay.
But it's still 500 feet.
Okay.
Clerk Doyle, practically speaking, through the medical marijuana application process, did you receive feedback from any past applicants in terms of the scale location map as it related to parks? Any feedback or intel that jogs your memory as it related to playground equipment versus no playground equipment?
So, Mr. President, what this all stems from is the previous administration was trying to label Hidden River Park downtown, that's gathering space, as a park. So that's why a reference was made to playground equipment, since no playground equipment existed in Hidden River Park. But that subsequently has come out of our master plan, Hidden River Park, because it was in the master plan. So that was the only reason why that was put in there. So, because it would have eliminated a number of the downtown options for medical marijuana sites.
So I'll let Councilman James have the floor before I give you the floor.
Well, I would just say that Hidden River Park was really never, a park has to be a park because it's been designated as a park by a city, and it's been included in that approved Parks and Rec Master Plan, which Hidden River Park was never a park to an approved Parks and Recreation Master Plan. So it really was never really a park at all.
Hidden River Plaza.
Yeah. Just to clarify, it actually was in the Parks and Masters Plan, and the previous council took it out of that master plan, so where it couldn't be classified as a park.
The master plan, the older master plan was amended to include Hidden River Park?
No, to
Because it was-
remove it from, it was initially in the master plan, and the council took it out of the master plan.
It took it out of the proposed master plan, but that,
Existing older one.
yeah, the older master plan, it was never in the approved, that's why I use the word approved. The master plan that was posted on the website, Hidden River was never a part of the approved master plan, which was expired, by the way, for the city of Pontiac. So it was, the discussion was in the proposed master plan, which is now the new master plan for Parks and Rec.
All I say is it was removed out of the master plan, so where it would not be an issue
Yes,
in this matter.
yeah.
Attorney Murphy, further information you'd like us to provide or, for
I
us
did.
to deliberate?
I did review the scaled location maps that were submitted by the 20 conditionally approved medical marijuana applicants, and I didn't find any where the buffering to the park was an issue by changing this playground equipment definition. They were almost all of them were more than 1,000 feet away from parks. In fact, most of them were 2,000 feet away from parks.
So any other rationale? I mean, so the current medical ordinance uses this language, and your hope and intent for it to create essentially more broad or a different language, is it just to make it cleaner and tidier, or is there other implications that you'd like for council to consider?
You mean for me?
Yeah.
Yeah, that the fact that we're using playground equipment as a measurement is totally inappropriate. If the idea is that we don't want these businesses that close to parks because children and families are playing in those parks, you need to be looking at the measurement of the park itself, because a child could be playing anywhere in that park. If that's the idea, that we want to keep these things separated from, children being at play. We don't want to look at where a piece of play equipment is in the park, because then you're looking at, the possibility of you're moving play equipment to qualify various people to be able to qualify to have a business there. And I don't think we really want to do that. I think we want to look at how close that business is to the entrance, to the perimeter of the park itself, understanding that children can play in any place in the park. Whether there's play equipment or not. Most parks do have play equipment, but whether there's play equipment or not, the children can play in any part of that park. So we don't want to signal out play equipment and say we're going to measure from this piece of play equipment. That doesn't really make sense. We need to measure from the perimeter of the park and assume that anywhere in that park, children and families can be playing, and we want this business to be X distance away from that activity. So I think this change gives us what we want here.
Any further discussion? Hearing no further discussion, roll call on the proposed amendment, which would eliminate the reference to a scaled location area map that identifies the relative locations of and distances from public parks containing playground equipment, and make it more so the primary point of ingress to the park. So, Clerk Doyle, roll call.
Parker?
Yes.
Carrington?
Yes.
Goodman?
Yes.
James?
Yes?
McGinnis?
Yes.
Nicholson?
Yes.
6 yeas, no nays.
That motion carries. The amendment passes. Next, it's on pages 20 and 21. It's section 13C. It's proposed to be amended that it would read, that letter C, after 60 days from the effective date of this ordinance, the clerk shall begin accepting adult-use marijuana business applications for a permit to operate a grower, processor,